It is one of the most widely ratified human rights treaties in the modern day world. And it is one of the most influential human rights treaties in the contemporary world. Since its adoption by the UN General Assembly in 1964, this particular convention has prompted states across the globe, in the industrialized world, in the developing world, to do away with discrimination on the basis of race in employment, in criminal justice, in public services, in virtually every arena. It is, again, one of the most influential human rights treaties adopted in the modern day era. As I note here on the screen, Article 2 of the International Convention on the Elimination of All Forms of Racial Discrimination, ratified by the US in 1994, explicitly enjoins the state party to, quote, pursue by all appropriate means and without delay a policy of eliminating racial discrimination. It is unequivocal. It is crystal clear, easy to comprehend, easy to understand. As I note here, the United States is a signatory, having ratified the convention in 1994. Any constitutional scholars present? Well, if so, you know that the Supremacy Clause of the US Constitution essentially establishes that treaties enacted under its authority constitute the supreme law of the land. That is, any treaty signed by the United States obligates the US to fulfill its terms. Well, as the stats I showed you earlier indicate, the US isn't exactly meeting its obligations and commitments under the terms of this particular convention. Article 5 of this particular convention requires the state party, the signatory, to ensure and protect, quote, the right of equal treatment before the tribunals and all other organs administering justice. All other organs administering justice. Are African Americans and other racial minorities in the US receiving equal treatment before organs administering justice in the United States? These stats that I shared with you a moment or two ago say no. In fact, they say the answer is unequivocally no. As I note here, the committee responsible for overseeing and enforcing this particular convention, the United Nations Committee on the Elimination of Racial Discrimination, has repeatedly stressed that the racial disparities in the American criminal justice system constitute a grave violation of this convention and its provisions. But the disparities persist. They continue unabated. American policymakers, including the current administration, have repeatedly pledged to adhere to this convention, to address the racial disparities that plague our criminal justice system, but the problem persists, again, including under the current administration. Well, why is this of any consequence, you ask? So we're not adhering to some human rights treaty. Many countries fail to fulfill their commitments and obligations. So what? It's just one treaty. Why is this of any consequence? I'll tell you why. Because our country is a dominant actor in international affairs. If we fail to fulfill our obligations and commitments, then other nation states across the globe will surely follow suit. And of course, let's not forget the fact that our country purports to be a champion of human rights and human dignity. We claim we are a beacon of light in the modern world. But how can we make such a claim? How can we make such an assertion if we fail to adhere to these human rights treaties that we have signed and ratified? Amidst all the discussion about criminal justice reform, the fact that the racial disparities in our criminal justice system violates international accords and agreements that our country has signed and ratified is never broached. It is never touched upon. But it is a cornerstone of my particular Capstone project. Forgive me if I digress for a moment here, but we have a presidential campaign underway at present. I'm sure many of you are following it. This particular convention, which again calls for the abolition of all forms of racial discrimination, was adopted and ratified during the Clinton administration. in 1994. 1994, the Clinton administration made a commitment under the terms of this accord to do away with all forms of racial discrimination. But in that same year, in 1994, the Clinton White House, of course, embraced and engineered a crime bill that resulted in the very racial disparities that plague our criminal justice system today. So on the one hand, the Clinton administration called for the abolition of all forms of discrimination, while at the same time adopting legislation that resulted in discrimination on a broad scale against ethnic minorities in the criminal justice system. I, for one, would love an explanation from the presidential frontrunner of the Democratic Party for this particular discrepancy, especially as she courts the votes of certain segments of the American population. As I noted earlier, mass incarceration and criminal justice reform has certainly attracted a good deal of attention as of late. Much of this attention, however, has been focused on police, on law enforcement officers in particular. Black Lives Matter, other activist organizations continually focus their attention when it comes to criminal justice reform on police. But as I explained in my Capstone project, police officers are not the key actors in the American criminal justice system. No, prosecutors, not police, are the pivotal actors in the American criminal justice system. As I note here, the UN Committee on the Elimination of All Forms of Racial Discrimination has stressed that racial disparities in the American criminal justice system are exacerbated. They are made worse by the use, I would say the continual abuse, of prosecutorial discretion. You see, prosecutors in the United States, in American courtrooms, enjoy sweeping and almost unlimited power and discretion. From the decision whether to prosecute a defendant, to the nature and character of the charges against the defendant, to the number of charges against a defendant, prosecutors enjoy unlimited discretion and power. And of course, prosecutors dominate the plea bargaining process as well. They enjoy innate inherent advantages in that process. Only a prosecutor, of course, can determine and decide who gets a plea offer in the first place. To make matters worse, in the American criminal justice system, prosecutors enjoy almost total immunity, and are seldom, if ever, held accountable for mistakes and errors in judgment. I'm sure you're all aware of the fact that there have been countless instances in the past decade of individuals who served years, decades in some cases, for crimes they did not commit, who were later exonerated. Even in cases of this kind, prosecutors are not held accountable, are seldom, if ever, punished or even chastised by state bars, disciplinary committees, etc., etc. Prosecutors in the American criminal justice system